If you've received a notice of deposition, you need to understand what a deposition is and how to successfully participate in one. Any mistakes made in a deposition may come back to haunt you later if your case goes to trial. So you want to make sure you're well prepared. In this video, we'll explain what a deposition is and offer our tips for a successful deposition. A deposition is a legal term for a formal recorded question and answer session. Depositions are important parts of the discovery process in litigated matters. A deposition draws out information relevant to a case and preserves the witness testimonies for later use when filing motions with the court or a trial. The person asking the questions is called the examiner. The person being questioned is called the witness. The witness is under oath to tell the truth. The examiner, usually one of the attorneys, they will ask the witness a series of questions to obtain relevant information and help their client establish their case. Usually the deposition is recorded by a stenographer who creates a written record of the proceedings. In a video deposition, a video recording will be made of the proceedings as well. Before going to a deposition, you'll want to prepare thoroughly. The first step is to make sure you've retained an experienced trust litigation lawyer to represent you. Prior to the deposition, meet with your attorney for a preparation session. Review key documents and events together. Ask your attorney to offer examples of the types of questions that you'll be asked. If you're particularly nervous about certain lines of questions, your attorney can counsel you on the best way to respond. If a video deposition is being taken, be conscious of your dress and grooming. Keep in mind that a judge may someday view the recording if the case proceeds to trial. Now that we've established what a deposition is and how to prepare, here are 6 tips for a successful deposition. Number 1, tell the truth. Before your deposition, you'll take an oath to tell the truth. Lying under oath carries the same penalties as perjury and will destroy your case. Number 2, make sure that you understand the examiner's questions before answering. Listen carefully to the question, pause, and then answer only if you understand the question. If you don't understand, ask the examiner to rephrase the question. If a question misstates a fact, correct them in your answer. Number 3, remember the deposition will result in a transcript. Avoid nonverbal answers which can't be included in the written record being created. All responses must be said out loud. Instead of saying, nodding your head, or using hand gestures, give an audible reply to the questions. Since the transcript may someday be used in a trial, be careful in what you say and how you phrase your statements. Instead of answering questions immediately with the first thought that comes to mind, take your time in forming an accurate response. The deposition transcript won't reflect pauses, only your verbal responses. It's better to take your time. Number 4, keep your answers succinct. Only answer the question that was asked. Do not help the examiner or offer more information than is requested. If you overshare information, you risk handing your opponent's case to them on a silver platter. Number 5, stick to what you know. Your response should be limited to what you saw, heard, or did. If you don't know or remember the answer to a question, simply say, I don't know, or I can't recall. Do not guess or speculate. Number 6, try to remain calm and neutral. Now is not the time to try and prove your case. Just tell your side of the story in an accurate and neutral manner. Avoid becoming argumentative, apologetic, or defensive with the examiner. Leave the defense to your attorney. You may be wondering, do I have to answer all the questions I'm asked? A witness is required to answer most, but not all questions the examiner asks them. Witnesses do not have to answer the following types of questions. Private information, such things as your health, sexuality, or religious beliefs. Privileged information, information that's confidential, like a conversation you had between your lawyer or your doctor, your priest, or your spouse. So there you have it, some tips for conducting a successful deposition. If you have any questions about this video, please feel free to contact our office. Thanks.
We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhttrustlaw.com. Thanks.